Once Upon a Time in Britannia, Part 2. The writer had been living next door to a provincial solicitor's when he saw that first episode of Britannia. Their first-floor offices were literally terraced next to the room where he'd watched it, the room where he'd written his script. It was only logical that he would approach them for the legal advice which he hoped would bring about judicial action against those he felt certain had wronged him. So, safe in the knowledge that it was surely the solicitor's obligation to treat any information he passed on as highly confidential, late on one autumnal afternoon he went into the offices next door. He gave an outline of the case to the receptionist there at the neighbouring branch, who said she'd have to ask for advice and would pass on the details to another one of their offices. The writer left his business card and was told to expect a call from one of her colleagues. A couple of weeks or so passed, and the writer took that call and gave the man on the other end of the line a detailed account of all that had happened. By that stage, he'd received the letter from his ex-tutor, the highly respected screenwriter, and so the writer was mindful to point out that it wasn't just him who believed the similarities in Britannia were too many and too specific to be coincidental to his own body of work, but that of an academic and expert. The solicitor's response was that they didn't have an intellectual property specialist in-house that could deal with such a case. It was simply too large and too complex for them to take on board. But he did recommend another lawyer that he knew, one who was a specialist in this field. The writer spoke to that lawyer, his helpful neighbours had suggested, immediately. He certainly seemed like someone who would know all about copyright law and infringements. Whilst acknowledging the merit of the writer's case, the new lawyer advised him at first that he would need in the region of a six-figure sum in order to potentially start the proceedings through his firm. It was, after all, a case for the High Court. Now, as the epitome of struggling writer, at that stage in his life, our protagonist simply didn't have that kind of money at hand. So he made an approach to the Writers' Guild, who he'd joined as an associate member, to see if they could do anything on his behalf. Members of the guild looked into the case, took it seriously, and consulted their lawyer. But the ultimate advice that lawyer provided was that without any hard evidence linking the journalist to the producer, which at that stage the writer didn't have, there was little that could be done in proving his work had been illegally adapted. Irrespective of any similarities, demonstrating an opportunity to copy was a requisite of UK copyright law. The lawyer did note the similarities and also pointed out what the writer believed had to have been the adaptations. They suggested that a potential breach of confidence claim would be something he would stand a greater chance of winning, at that stage at least. However, until he could prove the link between the journalist and the producer, it would simply be a case of his word against hers. The guild wasn't able to provide him with any further support. Unperturbed, he did after all have the backing from within academia and witnesses who he'd told who the journalist had wanted to show his work to when she'd first mentioned them. The writer decided to try and resolve the matter himself. So he wrote to the producer/creator of Britannia to ask for his take on things directly. Perhaps he wasn't aware himself of the original source of the script. Based on other things that the journalist had previously written about her modus operandi, it was certainly a plausible option. The producer's response came via a conduit, his firm's head of legal and business. Remember the name. He wrote back, saying the producer denied having any knowledge of the writer's work and ideas. He went on to add that he believed that nobody involved in Britannia's creation could have been influenced by Tribus, even on a subconscious level. He mentioned a fourth name involved in the creation of their show, but not the journalist. Exacerbated and starting to realise that without serious financial backing, his attempts at seeking justice would never get off the ground, he then approached a legal crowdfunding website. They quickly assessed and accepted his case, but said he'd need a lawyer in place to receive any funds that were raised by their future potential backers. knowing that the lawyer his neighbours had recommended had genuinely seemed to have seen the merit in the case, and had even discussed a figure they'd need in order to proceed. He got back in touch and sent him a video that he'd prepared with a detailed breakdown of the similarities. After discussing the situation with his colleagues, the lawyer was very keen to meet the writer in person. He said that it would be best if he avoided the crowdfunding route altogether, and soon after offered to represent him on a contingency basis. The writer was advised by his new lawyer and a colleague not to make his video available publicly or speak about the case in the public domain, as, according to them, it would possibly damage his position or lead to a claim of libel. Not that the writer was in any way concerned about the latter. The truth is the truth after all. Nevertheless, he took on board their advice. By this stage, things were finally starting to look positive for the protagonist in this story. After being sent the script, the new lawyer and his colleagues, who he was told had all recognised the similarities, were very positive about it and seemed to agree that his intellectual property was being infringed upon. They took a detailed statement from him and began working on a letter of claim. That document, when finished, would eventually be addressed to the producer via his company, with copies due to be sent to Britannia's copyright holders, their partners in the show, and a host of others involved in its creation and production. There were even discussions as to what figure the writer would hypothetically settle for, although he made it clear that it was not just a matter of money to him, but the realization of his dreams and years of hard work. He wanted to receive what he was sure were his rightful credits. Whilst waiting for the letter of claim to be finalised, a number of developments occurred. Firstly, in a conversation with a professor friend of his, the writer discussed a theory of calculating the odds of similarities occurring in both his own body of work and Britannia. It had been suggested by mathematicians he knew. As both shows' creators were claiming their work to have been independently created from the other at around the same moment in time, the professor opined that the theory of independent events occurring was valid and could be applied to this case. Based on that theory, the writer could demonstrate that there was a greater chance of finding matching strands of DNA than the two shows to have shared all the similar points that he had pointed out in his video. In fact, it was the professor who came up with that particular analogy. The writer noted some correspondence on Twitter between the producer's company and the journalist's brother. The language used seemed to indicate a certain level of familiarity. Then, after a frustratingly fruitless period, in which he had all but given up on his quest to find hard evidence linking the journalist herself to the producer, he miraculously stumbled across a photograph. It couldn't be, could it? The journalist is the woman in the middle of that photo. And the man next to her? Well, according to an eyewitness and several biometric tests, which confirmed the writer's suspicions when he first saw it, it was the producer, the man who she'd denied being the contact who she'd wanted to show the script to, the mastermind behind Britannia. That photograph, combined with the academic support regarding the similarities and the professor's confirmation of the validity of the theory of odds, would surely be enough evidence to guarantee success in a future civil trial. After all, the writer would only need to demonstrate to a judge that an adaptation was likely to have occurred. He didn't even need to prove it was beyond reasonable doubt, which he felt all the evidence pointed to by now anyway. But then another, far more alarming coincidence came to light. A couple of weeks later, whilst waiting for the letter of claim to be honed and sent, the writer decided to do a little digging via a professional networking site on those he was taking a stand against. He searched the name of the production company behind Britannia and soon found the publicly available page of their head of legal and business, the conduit that the producer had used to send his denial. The writer noted that he had started to work for the producer's company in November of the previous year, the very same month he had told the solicitors next door the full details about this most unusual and valuable of cases. He then scrolled down that head of legal's profile page and looked at those who'd publicly endorsed him, a dozen or so people from throughout his career. And then he noticed a certain name of one of those referees, the owner of one and the same solicitors next door. The writer was stunned. Now, whatever his or your thoughts are on this being a random coincidence, these things can and do randomly happen on occasion. Two things can be said with certainty. One, that the receptionist he initially spoke to at that firm next door had discussed his case in-house, meaning that the owner of the firm would surely have been made aware of it. It was, after all, worth a huge amount in potential fees. And secondly, that the owner not only knew the individual, the specialist in intellectual property now working for the producer, but had even publicly endorsed him. Considering there are around 11,000 law firms in the UK, some with multiple branches, and nearly 200,000 solicitors on the roll, thousands of whom, it's fair to assume, would have a specialist knowledge in IP, and with around 24 million private dwellings in England, what are the chances that the writer's next-door neighbours, one in those 11,000, would have recommended both his lawyer to him in November 2018, and for their owner to have recommended the man who had started to work for the producers he was trying to sue? That man had started to work for that company in exactly the same month, November 2018. Using the same theory of independent events occurring that his professor friend had endorsed, would no doubt indicate that the chances of this being a coincidence would be ridiculously, perhaps even miraculously small. With regards to this, the question that one should consider is it likely that the owner would have consulted that specialist he'd publicly endorsed about the writer's case? To the writer at least, such a question seems rhetorical. And if that owner had passed on such information, which of course was confidential, what would the legal implications be if it ended up being used against the writer somehow by a certain head of legal and business or a certain producer? After that discovery, his own lawyers decided not to send the letter of claim, adopting a strategy that the writer was at odds with. One of their arguments was that they wanted to protect themselves from being sued for libel, something that to this day he cannot understand. They said they wanted to consult with expert barristers. Whilst they did so, the process would take some time, he was advised. The writer felt he had no choice but to leave the property he was renting, next door to the solicitors he felt he could no longer trust. A later look at the producer's head of business and legal's profile page shows he also left his employment with them in the very same month. Over the summer, his lawyers informed him that they'd sent the case to 2 barristers, both of whom looked at it with interest, but neither of which, he was told, were prepared to take it on. Remember, the writer would still need to raise the funds to pay for them somehow, and any High Court fees. The cost of all this, he was advised by a knowledgeable third party in the meantime, would be in the region of £500,000. The writer also presented his lawyers with questions to the barristers that never seemed to get answered. Noting that his lawyers, who had at first seemed so highly positive about the merits of the case, had seemingly turned the proverbial 180. The writer ended up parting company with them. He later asked for a copy of correspondence between themselves and the barristers that they'd said they'd spoken to, but was not provided access to this, which leads us, at the time of recording, to the present day. At last, the writer has finally been able to speak publicly about the case, which he has done in the form of making these videos and creating a website as a platform on which to showcase them. He was even invited to give a lecture on screenwriting and copyright at a respected law school in central London. After presenting the students and faculty with a story there, not one person raised their hands when asked if they felt the similarities and links to Britannia and its producers could have been just a coincidence. However, he remains deeply concerned about the links of his former neighbours to both sides of this case. And how do I know all this? Well, that writer is me. I'd like to thank you for taking the time to listen to my story. I know more than anyone just how valuable time can be. Please do click on the link below and visit my website. And do like and comment on this video. You can also subscribe to my channel to find out about the third and final part of my story. It's a video that hasn't been made yet, as the final chapter in my case against Britannia and those involved in the potential suppressing of it has yet to be written. Cheers.